Well, then I think the court has to revisit not only the offer contained in our offer of proof, but the tapes as a whole in terms of the light that they shed on the credibility of Detective Furman with respect to the manufacturing of probable cause. Here we're talking about his believability in terms of all of the circumstances leading up to the decision to go over the wall and enter Mr. Simpson's premises. That was a very close issue, both at the preliminary hearing and I believe in the motion that was renewed in this court. And we believe that this newly discovered evidence is of such weight that the court will be compelled to come to a different conclusion with respect to the credibility of the explanation of the reason that the officers entered the premises and will be required to suppress all of the evidence found as a result.
And you anticipate recalling Detective Furman?
Yes, Your Honor.
For that purpose?
Yes.
All right. Mr. Hodgman, Ms. Clark?
We'd be ready to proceed on that Tuesday morning.
Any response to the defense request to reopen based upon 1538.5, newly discovered evidence?
Urge the defense to file their motion. But I would remind the court that I'd like to see what the defense has to argue in this regard. I would remind the court that the testimony concerning probable cause was elicited from Detective Van Adder and I believe Detective Lang as well in numerous motions. But Detective Furman's testimony was cumulative to theirs. So how the tapes may impact on his credibility, I frankly fail to see how that's going to have any impact on the ultimate determination of probable cause. But if the defense thinks they have an argument to make, of course they'll make it, and
you'll concede though that the Furman tapes are newly discovered.
I will concede that.
Subsequent to the 1538.5, both at the preliminary hearing and in the Superior Court.
Yes, Your Honor. Yeah, there's no dispute about that. Whether they're relevant or whether they have any impact on the determination of probable cause is another matter, but they are newly discovered.
All right. That's so true. I think the defense is entitled to make the motion.
Yes.
All right.
Yes. I agree.
Okay.
That's it.
All right, then, just for scheduling purposes, then, Dean Allman, you'll probably have that filed by Tuesday?
Yes.
Okay.
We're going to need time to examine it and respond, Your Honor. Obviously, if they file it Tuesday morning, we're not going to be ready to respond.
I understand that when they file it, you can take a look at it, see how much time you think you need to respond. But since the issues have already been framed, and since we have significant testimony already in the record, and that the subsequent hearing would likely involve the recalling of Detective Furman, I mean, it's a pretty precise issue since the newly discovered evidence deals only with Detective Furman.
Well, we urge the court to urge the defense to give us some points and authorities as to why they feel they would need to recall Detective Furman for that purpose. Well, they have the tapes. No, I'm serious, Your Honor. To the extent that they have impeaching material on them, they are 10 years prior to the events of the night of June the 12th, 1994.
Well, let's not argue, Ms. Clark, let's not argue the merits of it now.
I'm not even attempting to. I just don't know why we need to elicit further testimony from him.
Well, I mean, it might be interesting to know if there's a factual basis for some of those matters.
The motion was filed this morning. The only thing we still need to file at Your Honor's request is a specific identification of portions of the Furman tapes that we believe are relevant to this determination. We believe we're entitled to reopen the motion and re-examine Detective Furman prior to calling and cross-examining him as a witness at the trial. So we'd like to proceed with that as expeditiously as possible so we can then proceed to concluding our case for the trial.
All right, Mr. Allman, let me direct you then to facts to the prosecution and to the court. Any supplemental memorandum of points authorities if you work on it over the weekend. And so hopefully we can get this up and running because I'm concerned that our jury is sitting here again.
Yes, we are too.
All right.
Just for the record, Yesterday, I was provided DNA discovery pages 9679 through 9688, which are entitled Personal Notes of Brad Popovich regarding People of California versus Orenthal James Simpsons, which really are nothing more than recitations of his visits to 3 different laboratories. There is no report.
If there is a report, they're not going to turn it over.
Well, I don't know why. If she's seen a report, as she just said, and Mr. Hodgman said, where is it? I'm not ill-informed.
Ms. Clark?
Your Honor, I guess reasonable minds can differ about what is a report. This, looked like a report to me. It details what he saw, what he did at the laboratories, and we turned it over. We have given them everything we have.
Well,
What else can we do? Your Honor, we give discovery when we get it. If we have notes, if we have reports, we turn them over. We have nothing more than what we've given them.
I'm just,
I don't know what else we can be required to do.
I don't know how anybody can look at a document that saes personal notes
Well,
and then
counsel,
turn around and say
If
it's a
that's all they
report.
have, and that's what Dr. Popovich calls a report, that's a report.
No. These are called, this is what Dr. Popovich in his own writing calls personal notes. It is not a report. If there is a report, or there's going to be a report, or there should be a report, and she's indicating she saw a report,
She's saying this is the report.
well, these are notes. They're entitled notes. There is no report.
What's the note, what's the report?
All right. Thank you.
Yeah, that's the bottom line.
Thank you. Mr. Bailey?
Please the court, mindful as we are of the fact that the jury needs to conclude this case, we brought into town on Tuesday to have them at the ready 2 witnesses from the other side of the country relating to Mr. Furman. Their names have been listed. The notes of their interviews were turned over a long, long time ago. They are Natalie Singer. Natalie Singer in 1987 suffered a kidney stone attack, was taken to the hospital. While there, her roommate met 2 officers in the emergency room, Mark Furman and Tom Vetrano, his then partner. Ms. Hannock, the roommate, became friendly with Officer Vetrano, who used to visit the apartment of Hannock and Singer with Mark Furman. On the very first visit, with Ms. Singer present in the room, it is a very small apartment, or was, Mark Furman regaled his audience with tales of how he liked to take niggers into the alley and hit them with a baton and practice his kicks upon them until they twitched, and how it relieved his tensions to have such an experience. He visited 1 or 2 more times to the disgust of this witness, and finally, on a 3rd or 4th occasion, she was looking out her bathroom window when the pair arrived, on duty, uniform, but of course taking a little time off to socialize. As they started up the sidewalk, she yelled out the window, "Hello, Tom." Officer Furman responded in vintage Furman, "That fucking bitch." At which point, principally because of his revolting racial conduct, she ordered him never to come in the apartment again. He went back to the cruiser. Vetrano came in and visited. Vetrano was a witness to each of Furman's utterances that I have described. This occurred in the fall of 1987. In late 1986, Mark Furman made the acquaintance, I use that word sparingly, of Roderick Hodge, recently released from active duty in the Marine Corps, a member of the Reserve, who was earning his room and board by supervising a certain small apartment building within Furman's territory. Furman had expressed an interest in Hodge's brother-in-law, one Sykes by name, now deceased, and was querying Hodge on a regular basis as to whether he and Sykes were involved in some illicit activity. On January 10th, 1987, Hodge came out of a passageway in the building that he supervised and knocked down someone that he didn't recognize. The following day, officers came to arrest him, and Officer Furman and Vetrano took him downtown in the cruiser. Vetrano was driving. Furman was in the front seat. Officer Furman turned around and said to Hodge, "I told you I'd get you, nigger." He then learned and commented unfavorably on the fact that Mr. Hodge's mother is white. and that the couple is racially mixed. At the police station, he told Mr. Hodge to undress and bend over, and while looking at his backside said, "You do all look alike, don't you?" Hodge was then prosecuted not on the charge of assaulting Mark Furman, for which he was arrested, but on some kind of conspiracy charge having to do with drugs. He and his co-defendant, I believe a man named Earl Gray, were tried in the Superior Court in West Los Angeles in Santa Monica and acquitted. Those are the two witnesses that we have available. Now, you had indicated earlier, and I took a moment to reaffirm Your Honor's ruling made many months ago, that in order to cross-examine Mark Furman on incidents such as this, and this ruling arose from the Cordoba confusion, as you remember, that it would be necessary that the witnesses testify and that you have some assurance that they would say what the offer of proof said that they would say, and I believe it appropriate to put them on, as well as Angela Terry and Kathleen Bell having been introduced into this case by the prosecution for the purpose of showing that she lied about even knowing Furman, and therefore a witness who I assume is not only permissible but essential at this point. We will prove that she knew him far too well. They are scheduled for Tuesday. First up, once you have whatever legal matters are necessary out of the way. The remaining two witnesses are Furman's partner, Vetrano. We obviously have a foundation to ask him whether or not he was present at the several incidents I have described, because the witnesses by that point will have said so, and then he can decide how he will respond, whether or not he heard these words. And finally, we have Dr. Goulston, employed by the prosecution apparently to condition, and we think possibly medicate, Mark Furman for his performance on that stand, who sat here. When I pointed to him and asked Furman if he knew him, he said he didn't, and the prosecutors sat silent, knowing full well that he was a member of their team. Those are the people that we have, in addition to Kathleen Bell and Angela Terry, that we would like to put on. We are prepared to put Ms. Singer and Mr. Hodge on this morning so that we don't waste the morning. Thank you.
You know, I think we're way beyond the point of what is ridiculous. But let me say this. The court ruled earlier that neither Hodge nor Singer would be allowed to testify in these proceedings unless and until the court had the opportunity to hear from Kathleen Bell and Andrea Terry. There was a 352 issue as to Hodge and Singer. Sherry Lewis filed a motion with the court and argued that issue to the court, and the court issued its ruling. I don't know why they have Hodge and Terry here today. The court has not indicated that they will be allowed to testify in this proceeding. I haven't read the file completely on Hodge and Terry. However,
Hodge and Singer.
I'm sorry, Hodge and Singer. But in the event that they do call Mr. Hodge at some point, then, you know, we'll have another little mini trial in this case, the mini trial of Mr. Hodge. At any point or any event, I'm not ready for that. The court shouldn't allow them to attempt to force us into hearing testimony from these two witnesses today. I will say this: some of what I hear today from Mr. Bailey, I have never heard or read before. I think there may be a discovery issue on some of what Mr. Bailey said. At any event, we're not ready to go forward on Singer and Hodge. We have had no indication from the court that they'll be allowed to testify. I don't know why the defense doesn't have witnesses here today, witnesses who are on the witness list and who have been approved by the court already as witnesses who have relevant and probative testimony to offer this jury. And what's going on here today? Are we going to allow the jury to sit another day and then 3 days over the weekend?
No, we might work tomorrow.
We should work tomorrow. We should work tonight. And let's get this thing on, Judge. If they want to call Andrea Terry or Kathleen Bell, they did not indicate that they would call them today, but I will prepare to cross-examine those witnesses, myself and Ms. Clark. We'll get ready this morning, if they like. But Singer and Hodge, they should be off limits, as they have been.
Mr. Bailey?
I also called Mr. Taylor Daigneault, who was inscripting or enrolling his daughter in college in Michigan and had planned to spend the week there on Tuesday, and said so that not to delay the court, we did not anticipate you would be 2 days making a ruling, that we needed to have him here with Miss Bell. Now, we have never spoken Miss Bell, and I don't think they have either. She's willing to testify, and that's it. He came all the way back the following morning, anticipating that he would be here with his client. When we found out the ruling would come down Friday morning, we anticipated the morning would be spent putting in the evidence that you would permit as to Laura Hart McKinney. We didn't learn till last night that that would be much truncated. I had already committed to Mr. Taylor Daniel down in Torrance that he would be the first witness Monday, because I thought we could get rid of the two witnesses who are now asked to sit here the whole Labor Day weekend because Mr. Darden isn't ready. Mr. Darden is able to get ready very quickly. He's known all about these people. These are the last witnesses in the case. And if he's not ready to confront them, when they finish testifying, I recommend that he sit down, because he knows, as the jury never will, that they're telling the absolute truth. I would like to put them on today and not put them up over the weekend. They would like to go home. And the jury would like to hear some evidence.
Your Honor, Mr. Bailey, scheduled witnesses in derogation of the court's own order. We have no duty to be ready on these witnesses, no responsibility whatsoever, and we are not. And I'm sorry that that upsets Mr. Bailey. I'm sorry that he is upset with the court's ruling. But it's been 3 days now.
Excuse me. When will Kathleen Bell be available?
Tuesday morning.
Why not Saturday morning?
Might be able to get here tomorrow, but I thought if we got to anyone today, I held them specifically on the unlikelihood that you would be able to hear them today because we would be tied up with other matters. On the chance that they could go home, Ms. Singer and Mr. Hodge. In addition, Your Honor, Mr. Hodge is here with his lawyer, who's been here since Wednesday, and we're bearing those expenses, as we must. Now, to say that families can't spend the Labor Day weekend together because Mr. Darden is ready to cross-examine is a pretty poor response, I think.
You know, we'll miss some cartoons tomorrow. We can work through the day. No big deal, Your Honor. Ready to move along.
All right, what else do you have besides Hodge and Singer available today? How about Miss McKinney?
So we have one other motion like this is relevant.
All right.
This is the so-called Brady motion that I told the court earlier this week I'd be filing. And I think this matter deserves this court's very, very serious consideration. And it's a very serious motion, and we take it seriously. And specifically, what I'd like the court to be aware of is the declaration of a deputy district attorney by the name of Lucienne Coleman. In this declaration, she spells out in detail, through conversations with Sean Snyder Chapman of my office, what we think.
My recollection is that during one of our, I don't recollect if it was a 1054.7 or a pitches, I think it was a pitches motion. My recollection is that I ordered the disclosure of a statement that Ms. Coleman gave. Is
Yes,
that correct?
you did, Your Honor, and a redacted statement that addresses, and I'd like to talk about that. The statement we got does not comport with what she says the facts are, and it's very, very serious. So the court will allow me, I'd like to spell this out. This is a matter in which Ms. Coleman is on a day off today. She is standing by the phone and is available should you want her to testify today. She has been a deputy district attorney for some 16 years, and I might indicate that I was the assistant DA when she was hired, and I've known her for a very long time. That has nothing to do with what she's done in this case, however. She, on July 19th, 1994, she was working in complaints, and at that time, she had a conversation with LAPD homicide detective Andy Purdy here in this building, and Purdy was there to file a case. At that time, this story had first surfaced about the possibility of Furman planting the glove at Rockingham. And she indicated to Purdy at that time and commented how ridiculous she thought that thought was. Purdy responded that these allegations were not ridiculous at all and that he wouldn't put any such thing past Furman. He then went on to tell Lucienne Coleman about his experiences in working with Furman at West LA Station, Your Honor. At that time, Purdy had recently married a Jewish woman, and he returned from apparently his honeymoon or whatever, and it was his contention that Furman had painted Purdy's locker with swastikas. And during this conversation, Purdy, Ms. Coleman, and another DA by the name of Julie Sergogian walked up, and they heard many of the things that Purdy was saying about Furman. Later on, and in July of 1994, Deputy DA Ellen Burke told Lucien Coleman about a black officer who had heard Furman at a picnic or barbecue talking about and discussing his relationship with Nicole Simpson. Quote, that her quote-unquote boob job had looked real great. Burke did not tell the name of the black officer at the time, but Ms. Coleman later confirmed that it was an officer named Maxwell. Some of these names may become relevant to you when you think back of what you saw. And then continuing on, a day or two later, an LAPD detective by the name of Mark Arneson, this is in July of 1994, Your Honor, came to file a case before Lucien Coleman. The topic, as usual, then turned to Simpson. And Arneson,
Excuse me, Mr. Chairman. Your Honor, I would point out for the court, at this point in time, Mr. Cochran is reading, apparently for the benefit of the public, what is contained in a declaration filed under seal to the court. Has the court had an opportunity to review this declaration?
No, it matters.
Nor have we.
Took to the bench before.
two things. First of all, it's not filed under seal, and I'm not reading it. I'm using the references to speak out the facts as I understand it. As usual, Your Honor, they want to cut off everything that relates to them. This is a very important motion. I have a right to spell this out to the court. It's very serious, and it bears upon our ability to go forward at this point.
Proceed.
Thank you, Your Honor. So, as I indicated to the court, Arneson said that he already knew about the boob job comment, and that he had talked to two other officers who said they'd heard Furman make such statements about Nicole's breasts as well. Arneson did not say who these two officers were. Then, in the first 2 weeks of August of 1994, this deputy DA, Lucien Coleman, went to see Marcia Clark and Bill Hodgman, as she was troubled about the information that she had heard. Miss Clark, she says, had been a friend of hers for many years, and they'd been friends. And she found Clark and Hodgman in Clark's office and told them what she'd heard, what I just indicated to the court. By then, she had also heard that Furman walked around on weekends wearing Nazi paraphernalia. When she told Clark and Hodgman what she knew, Clark stated, "This is BS," in no uncertain terms. Hodgman suggested the office should look into these allegations. Clark said, "This is just BS being put out by the defense." Coleman then indicated that she hadn't heard any of these allegations from the defense, but rather from LAPD officers. And she suggested that the LA County District Attorney's Office look into these allegations. Now, Your Honor, it's important as I go through this, this was in the first 2 weeks of August of 1994. She then spoke with Clark and Hodgman about matters unrelated to Detective Furman. And thereafter, she suggested
Mr. Cochran,
that...
excuse me, forgive me for interrupting you, but refresh my recollection as to when it was those matters were just those, Ms. Coleman, Ms. Burke, Ms. Segogian, Detective Maxwell, Detective Purdy. My recollection is that the court ordered the disclosure of those reports to you with those names, but I'm just refresh my recollection as to when that occurred.
As I recall, Your Honor, and I don't have the exact date, Mr. Hodgman came down and indicated that he had a matter to discuss with the court. This was brought to the court's attention at some point. It started off by him saying he didn't think this had any basis in fact, but it was much, much later. It was this year. It was in maybe February or March of this year, and we can find out and let you know.
Okay.
What we got, Your Honor, was a redacted version, and you'll see when I tie this in. The version we got certainly bespeaks a cover-up or something, because what we got, you couldn't tell anything from this. And so that's the point I want to point out, and let me continue on if I might, Your Honor. This, so Marcia Clark continues on, "This is BS," says that over and over again, and then it goes on and says, I again suggested the DA's office look into these allegations because the defense would one day learn of the information and questions might be asked about why it had not been revealed to the DA's by the DA's office sooner. This is what this witness is prepared to testify as an honest deputy district attorney. She said, and this is what she quotes her former friend Marcia Clark is saying. She then angrily stated, Clark said, she was tired of other DAs trying to get involved in her case for their own self-aggrandizement. And she went on to say that she had no interest in this case other than doing the right thing and understanding what Brady mentioned. She also mentioned that she thought the information might prove false and they should really check it out. Later on, she saw Detective Arneson in the hall and asked him if the defense knew about the allegations against Furman. Of course, he said, well, perhaps they do because of Pavlik. And there's another deputy DA, Jeanette Bernstein, was present during that conversation. On August 24th, 1994, Your Honor, another key date, this deputy DA received a call, an irate call from Officer Purdy. And Purdy wanted to know if she had contacted the media about what he had told her. She told him that he hadn't. Purdy wanted to know why she'd informed Clark and Hodgman about their conversation. He was upset, and he told her at that time that he would deny having told her anything about Furman and that he would lie about the whole thing. And I told Purdy that if ever I had to testify, I would tell the truth, that he said he would lie. And she's, in fact, doing that now. On August 25th, 1994, Your Honor, after that, Purdy left a message for her to call him back. When she did, Purdy told me that his quote-unquote story was going to be that Furman was only suspected of having left the swastikas in his locker, that it was never proven. She reminded him that it was not what he had told her in July. Purdy's indicated that was going to be his story now. Purdy also said that he had kept a log, and this is a key thing. Purdy told Lucianne Coleman that he had kept a log of all incidents involving Furman when they both worked in West Los Angeles Station, but that he had destroyed the log that morning at 3:00 a.m. so that he would not have to turn it over to the prosecution. And that becomes a very key matter because Purdy, of course, remembers what's in that log, even if he did destroy it. On February 13th, 1995, Lucianne Coleman spoke to Bill Hodgman by telephone. And Hodgman told her that he had heard from 2 deputy DAs in the branch and area offices that they had some negative information about Furman. Now, this is in February now. Keep in mind, this all occurred in July and August earlier. She then had to remind Bill Hodgman of the conversation she'd had with Clark and he back in August. Hodgman claimed to have had no recollection of her ever discussing Furman during that conversation. And she reminded Mr. Hodgman of the information that she'd given back in August. He wanted the names of the officers who had given her the information and said he needed to check with the officers. And she said she needed to check with the officers first before she gave out their names. My recollection is that she called Purdy and told him she was going to give Hodgman his name. Purdy indicated that he would tell Hodgman the story he had mentioned in his prior conversation, not what he told her originally. She then proceeded to call Hodgman and gave him Purdy's name. She also told Hodgman about Purdy's log. And I don't think we ever saw anything about this log ever in any of the documents. And you'll have to search your memory as to what you were told in the conversation or when you got the records from IA. She relayed the conversation she'd had with Detective Arneson and gave Hodgman the names of Segogian and Burke as DAs who'd also heard some portions of these conversations. Hodgman and she had 3 or 4 conversations that night, and that's in February of 1995. Hodgman said that Detective Lang would be conducting the investigation into these allegations. Later, Hodgman said that Internal Affairs would be conducting the investigation. She called Burke and Segogian to tell them that she had given Hodgman their names and Internal Affairs would be contacting them shortly. On February 14th, Your Honor, 1995, while she was on vacation, she got a call from Purdy at home. And Purdy said that he had destroyed the logs, again, and that he would not testify against the prosecution no matter what. Purdy said that the LAPD was protecting Mark Furman because it felt that the defense was using Furman as a scapegoat. Purdy said he could lose his job for speaking out against Furman in view of the fact that the LAPD, and she quotes, was circling the wagons, end quote. On February 15th, she was in fact interviewed by Internal Affairs, and I think that'll probably be the date you'll find if you look back. She indicates this interview was more like was more of an interview, was more like an interrogation because of the hostile tone of the questioning and the type of questioning from these so-called investigators from IA. She said, she was asked questions, isn't it true that you think OJ Simpson is innocent and you want to have him acquitted? And did anyone besides your husband ever hear your telephone conversations with Officer Purdy? From February 16th to February 24th, this deputy DA requested of her office a copy of the tape of her interview with Internal Affairs. On February 24th, Mr. Hodgman indicated to her that a tape might be available for her that day. Later that day, Mr. Hodgman came to her and informed her that he discussed the matter with Assistant DA Frank Sunstead and that it had been decided that no copies of the tape should be released while this case was pending, because the tape might be Brady material and would then have to be turned over to the defense. Hodgman further indicated that it had also been decided that the tape should only be turned over as part of a pitcher's motion by the defense and would therefore not be given to me at that time. She still to this date does not have that tape and has told me that their office will not ask for the tape until the Simpson case is over. I told the officers, she goes on to say, from Internal Affairs, everything that I had been told, including the fact that Purdy had kept logs and had told me that he had destroyed them as he would never testify against the prosecution. Internal Affairs asked her if she thought Purdy had destroyed evidence. I said that I thought that Purdy would do anything to avoid testifying in this case, and further that Purdy had specifically told her he did not want to testify in any circumstances. This lady came to our office the other day. I didn't want to put her in a compromising position. I didn't issue a subpoena for her. She gave us this declaration. I asked her not to sign it, but to verify that it was true, because she was told, or has been told by one of her supervisors, that the DA's office wants to go slow on this, and that if she believes that if she signs this, she has to appear in this court. Let me quote. During the course of her conversation just last night with Sean Chapman, she's been told that at least one of her supervisors told her to go slow on this matter, and it's her feeling that if she signs this declaration, appears in this court, it will adversely affect her status of a deputy district attorney. However, she said she's willing to make that sacrifice because what they've done is wrong. It's from one of their own people. The court needs to take this and look back at what you gave us. The redacted version we had bears no semblance of this. We are entitled to this information. We should have had it back in July and August. We should have had it in February. What we got is a travesty. If you look at what we got, it doesn't make any sense at all. And we need this before we can go forward with Furman. They can talk all they want about witnesses and moving ahead. We have an absolute right in defending our client to have this information. This supposedly is a search for truth. I have my doubts, but I have to do everything I can for my client in this instance. And when these kind of things are happening, we have to demand an investigation. It doesn't matter to me if we work on Saturday, Sunday, holidays, or whatever. We do that anyway, Your Honor. That doesn't matter. But the point is, we need to have these matters resolved before we can go forward and effectively represent our clients. And I mentioned in court the other day that we were going to ask Your Honor to provide us with the questions asked of the DAs in camera regarding the meeting where Detective Furman was prepared, because we think that now with this additional information, we think it's entirely relevant. The court may not have known the appropriate questions to ask. And all we're trying to do, Your Honor, is have a level playing field here and to be able to get this information before the jury. Because I need hardly point out to this court, this is a jury trial. This is not a court trial. The jurors will decide the evidence in this case, and we have a right in representing Mr. Simpson. It's a fundamental constitutional right to have this information under Brady. And and you've seen other examples such as those photographs where we have possible exculpatory evidence. We want it. We have a right to have that before we go forward in this critical part of our case at the very end. And now we have somebody from their own office, and there are other DAs who I think will also back her up. Who's a very credible person who puts her job on the line in the interest of telling the truth and being honest in this matter. And we find out that there's been attempts to cover it up. And so there's only one way to put it. So we need a hearing on this. Take as much time as they want. She's on call. She can come down here today if they want. What I've indicated to you, she will say on the stand, and we need to resolve this.
All right, Mr. Cochran, just so I understand, the two matters that you find of interest in this discussion with Ms. Coleman is the observation by Detective Furman regarding Nicole Brown Simpson's anatomy, and secondly, the racial animosity regarding Jews. Is that correct?
Well, regarding
Those
Jews,
are the two.
well, yes, well, the swastikas and that sort of thing, but also, Your Honor, the log. I think if
And
this,
Purdy's log.
obviously, if there's a log of all his misconduct in West Los Angeles, I'm sure it'll track some of the things he's telling Laura McKinney about. We have a right to those things, Judge. I mean, I think as I think about it.
Let me ask you a question, though. If your recollection is correct, that in February or March, these names were turned over to you, in my recollection of our discussions and the hearings that I conducted, I recollect Detective Maxwell, Detective Purdy, obviously Ms. Coleman, Mr. Gogin, Ms. Burke, Detective Arneson, these names coming up, and those names were disclosed to you. And my recollection of the comment about Nicole Brown Simpson's breast enlargement was mentioned in those reports. I don't recollect if there was inquiry about the swastika incident. I don't recollect that, but I recollect something about swastikas. Have you had the opportunity to interview all of these individuals besides Ms. Coleman, Ms. Segogian?
We have, let me put it this way, Your Honor. First of all, Your Honor, let me say this as respectfully as I can. You may find it hard to believe, but some of us believe there is a conspiracy of silence Police officers aren't going to talk to us about this case. They don't talk to anybody. There's special rules regarding this case, Your Honor. They're not going to talk to us about this case. Deputy DAs, where their job is on the line, it's very hard to talk to them also. This Lucien Coleman is a very unique person, and there are some very fine deputy DAs up there who very well may do this, who may speak out regarding this. But there's no mention, and the point we had to rely upon, Your Honor, looking at this stuff. And I think there may have been some mention about Nicole Brown Simpson's anatomy. Nothing about these logs. I'm pretty clear about that, as I recall, that we ever got, and we can show you the redacted copy. But we got left, because let me tell you, in talking to Ms. Coleman, the redacted version was something she can hardly recognize. She wants the tape. She says if you get the tape, you will see how IA works. They came at her as though she was the worst person in the world. It was an interrogation where she was made to feel like she was some sort of a traitor in this instance, and it's outrageous. And that's what's actually happening here. So I mean, I don't think it's fair to put that back on us. We knew about certain things, and we're now trying to say to you that if these things are covered up, and there are other things, and I think you have to take this all together, Your Honor, just with regard to Henry Lee, as Barry Sheck has pointed out, those photographs that all of a sudden have been enhanced. We've been told there's no log, and now we find out all these things that Henry Lee immediately looks at the photographs and can tell their imprints walking in the back, that they have exculpatory evidence that they may not even know about. I mean, maybe part of this inadvertence, part of it may be negligence, part of it may be hiding it. But we have a right to Mr. Simpson. We cannot go any further without this.
So specifically, let's just get back to the fundamental of what you're asking here for then. Specifically, what you're asking for then is to make inquiry of Detective Purdy regarding this log in his recollection, correct?
Yes, we want to do that.
All right. And what else specifically?
We want, assuming the things that Ms. Coleman has indicated, we want to look at...
Because the evidence that would be of interest to you and your client would be observations, direct observations by another LAPD officer, supposedly Purdy or Maxwell, regarding relevant misconduct or racial animosity by Detective Furman, correct?
Absolutely.
All right.
And especially, and it also becomes very relevant if the prosecution knew about this early on, because they embraced this witness. And so, but I think we have, that's a pretty good starting point. Purdy, Coleman, if necessary, we have a declaration.
Well, Coleman is interesting only because she's the hearsay source for, somebody told me that Furman said this.
Right, Furman did this, and there was an investigation.
She directs the inquiry, but she's not firsthand.
See, Judge, the problem is, if you recall, and I'll try to provide this for you, what we get from you is a little redacted thing. Everything's all cut out, and so you may want to go back yourself and take a look at this. We want, though, Purdy, Maxwell, Arneson, we want all these people under oath. That's what we want. We want them under oath. We're not going to trust what they tell us. We're not going to trust them. We want them under oath, and we think we have a right to do that. And that's why I'm bringing this motion up now. So we could, the witnesses. I've been telling you for the last week and a half, the witnesses I have at the end. But we have, and so there's no secret about that. But in view of Your Honor's ruling and what you cut out of what we're able to do, we cannot go forward until we pursue these things. And it's very important to do that. So it doesn't matter. We don't mind working every day. If you want to have a hearing, have these officers here tomorrow, we'll be here. You want to have it tonight, we'll be here. You want to have it Sunday morning after I go to church, we'll be here. But the question is, let's get it on. But I think that we have a right to this. And as soon as we can, I want to take a break because I want to talk to Mr. Munger also, as I indicated to the court. That's another thing we have to deal with.
All right, Mr. Hodgman.
Your Honor, I have to confess I'm a mite perplexed by the defense bringing the motion at this particular time. As the court will recall, in February of this year, I brought these matters to the attention of the court. The court reviewed in camera a variety of material. I'm not sure what material, but presumably statements of the witnesses involved and various tapes. The court issued an order on March the 8th, 1995, directing that these materials be given to the defense. The defense had these witnesses' names. Apparently, and it is quite obvious, they've interviewed Ms. Coleman. They've had Officer Purdy's name, Detective Maxwell, and a number of other people's names, per the court's order, since March of this year. And I don't understand what we're doing here now. I presume that the court will make inquiry of the defense. Have they interviewed Detective Purdy or Officer Purdy? Have they interviewed Detective Maxwell?
They indicated no, they have not.
Well, they raise this now, and they indicate they'd like to have a Saturday session in order to pursue these matters. Where have they been with this information for the last 5 months? I brought it to the attention of the court last February. This information was in the hands of the defense before Detective Furman even testified. So I asked the court to take this into consideration as they review this motion. But the defense has had these materials. Apparently they've had tapes. They've had redacted reports that the court provided to them. I don't understand what they're doing here now, filing this motion. I can suspect certain things, but I would leave that unstated.
Mr. Cochran, would you provide to the court a copy of the reports and witness statements that you received?
I will. I just asked Mr. Douglas. Apparently it's in my office. I'm going to have it brought down here as soon as I can. He's going to call and get it down. Let me just respond briefly to Mr. Hodgman's question. First of all, I think you'll find, and I don't recall ever seeing anything about this log until Ms. Coleman told us about the log kept of Furman's activities. Also, Your Honor, as Lucy and Coleman would say.
I have to tell you that, that's why I asked if you would produce those materials, because my recollection of reading those materials was that the log was mentioned and that Purdy's desire not to get dragged into this case was apparent from the statement of Ms. Coleman. But be that as it, let me see what's there, and then we'll take it from
Let's do that.
point.
The other thing I just want to point out to the court, I mean, it's the height of naivete to stand here and say that we've been told that Purdy's going to lie. He tells the DA he's going to lie, the Deputy DA, Lucien Coleman. He's going to really tell us the truth. The question is, if he is going to lie, we need him under oath. We've seen we know that Furman has lied. We need him under oath. This whole thing has brought out the worst in these people, and we need to get them under oath to see. That's all we're saying. And so we can't be held to that standard. I mean, we know about these people. We're going to go over to the station and talk to Arneson. They'd stonewall IA. And IA takes this hostile ear toward one witness who's trying to tell the truth and says, get this stuff out. It may not be true. That's the point. I'll get it for you.
Give me stuff.
Certainly.
All right, well, I think that wraps it up at this point, as far as all your comments. All right, I think the thing we need to address first is whether or not we're going to have any testimony this morning. The court's previous ruling regarding Kathleen Bell was that her testimony was relevant for this reason. We have a unique situation where Detective Furman met Mr. Simpson and Nicole Brown Simpson in 1985. That Mr. Furman is again in contact indirectly with the defendant in 1989 at the request of the Los Angeles City Attorney's Office to prepare a statement regarding the 1985 incident. My recollection of that statement that Detective Furman provided to the City Attorney's Office for use in the domestic violence prosecution was that it was an incident that was indelibly impressed upon his memory, or words to that effect. Then we have the unusual circumstance in 1994 of Detective Furman then being brought into this case, being called out from his home as a homicide investigator. So we have that unusual circumstance first. We understand that Nicole Brown Simpson was Caucasian and that Mr. Simpson is African American. The offer of proof as to Kathleen Bell was that Detective Furman, in her presence and directly to her, made a statement that was indicative of racial animus, that was indicative of contempt of interracial couples, and was indicative of a willingness to harass and unlawfully detain interracial couples because of that fact. And I indicated at that time that I felt that that was a sufficient unusual and unique combination of events to make Kathleen Bell's testimony relevant. Subsequent to that finding, Detective Furman testified that he did not, in fact, refer to African Americans with a particular racial epithet And it appears that the offer of proof regarding Mr. Hodge does indicate that he was arrested by Mr. Furman, that Mr. Furman referred to him in a racially disparaging way and made 2 comments to him that are disparaging in nature and using the particular racial epithet in question. So that would appear to be direct impeachment evidence of Detective Furman. So I think there's an independent basis, a basis independent of Ms. Bell. The issue being, are you ready to cross-examine Mr. Hodge?
I've never gotten a discovery to cross-examine Mr. Hodge on this issue. I mean, I heard about this stuff for the first
Is there a
time.
statement?
Investigators noticed the only thing that was ever taken down, they were turned over, other than their attorney and the defense.
Not
Do you
only
have-
am I not being allowed an opportunity to prepare to cross-examine this witness.
Wait, did you have the name and address of Mr. Hodge?
Do I have a name and address for Mr. Hodge? Yes.
All right.
In Chicago, someplace in Illinois.
Did you make any effort to interview Mr. Hodge?
No, I did not. So Hodge,
And my
I'm sorry.
recollection is that Mr. Hodge, his name came up in our discussions back in January, if I recollect correctly.
I think his name came up in April, frankly, and he was the subject of a 352 motion and hearing filed by the prosecution and argued by Sherry Lewis. The court said he couldn't testify. So why would I go out and interview him, Judge?
Until Kathleen Bell had testified.
The court thought there might be a 352 issue. It might be cumulative.
Well, Kathleen Bell hasn't testified, and Mr. Hodge has testimony with regards to the, that is directly impeaching.
Except Mr. Bailey's.
Well, is Mr. Hodge here?
Yeah, earlier, so Ms. Singer.
All right. Why don't you make them available to talk to Mr. Darden?
So, court's prior ruling is out the door. I don't get to argue it. I don't get to prepare. We just jam the prosecution and put this man up here and have him testify in front of the jury, Judge.
Well, counsel, if you've known about him for 5 months and you haven't bothered to interview him, that's a problem. I agree.
You said he wasn't going to be a witness.
Until Kathleen Bell had testified. All right. The offer proof that I've heard here today indicates that he has direct impeachment testimony. We may not see Kathleen Bell. All right. I've had.
The court's.
I'm sorry?
Is Your Honor suggesting that Kathleen Bell wouldn't come to court, as I promised you she would?
No. I just said we may not see her testify. You may make a tactical decision after certain witnesses are called not to call her. I don't know.
I want you to bet your life on the fact that decision will not be made.
You know, I would like a 402 on this witness's testimony. Now,
All right.
are
Well-
we going to do that today? I have
Well-
2 boxes of material on Mr. Hodge.
What we're
How
going-
much time will I get to prepare?
Well,
And it's ready.
well,
She's promised a mini trial. That's
wait.
Yeah, there will be
No.
a mini trial.
No, there are no mini trials. What we'll do is we've had 2 requests now for a recess for Mr. Cochran to talk to Mr. Munger, and Mr. Bailey, I'm going to direct you to make Mr. Hodge and Ms. Singer available to Mr. Darden. All right, well,
I'm sorry, I didn't mean to interrupt. I apologize. But it's going to be Hodge and Singer as well?
at least Mr. Hodge. All right,
And they're going to testify.
They may
could
well.
potentially testify today.
unless you can tell me a good reason why, since you've known about them, that you're not ready.
Because you said they weren't going to be a witness in this case, because you have not ruled that their testimony is admissible, Judge.
Not what I said.
That is exactly what you
15.
said.
And maybe I can explain.
Please clear the courtroom.
All right, Mr. Cochran, did you have the opportunity to speak with Mr. Munger?
I did, Your Honor. Yes, thank you for the time. We were able to talk to him over in Department 104. Not as much time as we would like to have, obviously, so we're going to continue that conversation over this weekend, obviously, with Mr. Munger. But with regard to Mr. Hodge and Ms. Singer, they are present. And we can proceed now with Mr. Hodge, if the court pleases.
All right, I'll hear from Mr. Darden. And counsel, just so we're straight, I went back and reviewed the record regarding our discussions regarding Hodge and Singer, and that was after the court had made its ruling on Terry and Bell, indicating that it was premature to make a ruling as to Hodge and Singer because the objection was also 352 cumulative, and that the court would not be in a position to make a ruling on that unless and until I heard the testimony of Bell and Terry. So that's where we are.
Okay. And so that's where I am as well, Your Honor, having no indication, no firm indication that these witnesses would be allowed to testify.
All right, have you had the opportunity to interview Mr. Hodge and Ms. Singer?
Mr. Hodge refuses to speak with us. He is here represented by counsel from Illinois, as I understand it, whom I have not met as well. I did not get a chance to attempt to speak to Ms. Singer. I was busy attempting to gather my documents in this regard. We have a problem with Hodge, a discovery problem that we'd like to take up with the court. We also have a foundational problem, I think. And as I said before, we'd like a 402.
All right, what's the nature of the discovery?
Okay. Yeah. The prosecution filed its 352 motion on July 14, 1995, as it related to Mr. Hodge. And we included in that motion a copy of the discovery we were given as it related to Roderick Hodge. Nowhere in that discovery, from what I can discern, I should mention that these are handwritten notes. They are difficult, or somewhat difficult to read. I only have a Xerox copy. There are portions that are cut off or were cut off during the Xerox, and I complained about this on more than one occasion to the court and on the record. At any event, nowhere in this discovery is there any mention that Detective Furman, while transporting this man to the police station, turned to him and mentioned any racial epithet. And this is a document or report I assume was prepared by either Mr. Bailey himself or a defense investigator. And so we are surprised today to hear of this additional allegation.
My recollection, though, is that in our discussion back in March of 1995, that Mr. Bailey did, in fact, make an offer of proof regarding Mr. Hodge, and that offer of proof did include that first portion.
I'm sorry, Judge, Mr. Hodge.
Perhaps Mr. Blazier can find that. I'm looking somewhere around 18,599.
Okay, can Mr. Hodge be asked to step outside, Your Honor?
All right, is Mr. Hodge present in the court? All right, Mr. Hodge, would you step out of the courtroom, please? Thank you.
There's an offer of proof on July 27th. 39,038.
July 27th?
Yes.
Precise language I offered is in.
All right, that is correct. 39,039, starting at line 8. Do you have that, Mr.
I see that now, Your Honor. I apologize.
Okay.
Not having had a moment to prepare for this,
All
I
right.
overlooked that. Would the court inquire of the defense?
Well, let me tell you what my dilemma is. You are entitled to a reasonable opportunity to get prepared. I agree. I would like to present something to this jury today. The jury, I'm told, are not happy campers. Apparently, they came back from Catalina barking at the seals. That's a seaman's term, a fisherman's term, barking at the seals. It's being seasick.
It's not our fault.
No, I understand
The
that.
defense has no witnesses.
I understand it.
Here
I'm
today.
just saying if you can accommodate me and get ready on some of this stuff. But the dilemma that you pose and the dilemma that we create is that by calling Mr. Hodge first, that makes Bell cumulative. So, I mean, that's the situation we're in.
Certainly, we don't intend to make Bell cumulative. We don't think any. Your Honor, let me just say this. If you have 60, so many, I can hardly remember, 61 incidents on tape, which we no longer have, 59 have been thrown out, and we
Well, no,
have some
that's
live
not-
witnesses, Your Honor.
That's not correct, Mr.
Well, I read your order, Your Honor, and I, with all due respect, that order, there are some parts that are incoherent, and we would like to have some clarification of that, and we want to talk to you about that sometime today if possible, because we expect in perhaps a motion of reconsideration on Tuesday to address that, because certain parts we don't understand. And you said that's not correct. So maybe we're still entitled to do certain things that is not totally clear we can do. Is that what you're indicating?
No, that my order is very clear.
Not to us, Your Honor. So
Well, maybe it's, well,
it's not clear to us. Let me make that clear. Now, what I was going to suggest, we have Ms. Singer here. Why don't we start off? I haven't heard of complaining about Ms. Singer. Let's start with Ms. Singer. But we don't want, by calling Singer and Hodge, we're not saying this, we don't want to be duped into anything where later than Tuesday or Wednesday, we said, well, you call them, now you can't call Kathleen, Bell, and Terry.
I'm warning you, counsel. I'm just being, I told, this issue we brought up very early, that Hodge and Singer or anybody else might be cumulative after Terry and Bell, because it is a collateral issue. And at some point in time, it gets to be redundant.
Well,
So you have available to you the testimony of Bell, Terry, McKinney. McKinney can come in and testify that she interviewed Detective Furman over this 9-year period, that she tape recorded and transcribed these conversations, that during the course of these conversations, on 41 occasions that she can document, he referred to African Americans with a racial epithet and a negative and disparaging manner. 2 examples of which are X and Y, and that there is no doubt, and that the subplot of this particular screenplay was not the racial animosity, was not a subplot. That's what she can do.
all right, let me just ask you a question regarding that. One of the problems we have with that is the fact that the 2 instances you picked, first of all, you picked an instance on the tape that you can hardly hear the word. We don't think that's fair. The 2 most innocuous instances, we don't think that's fair. How could you
Mr.
arrive at
Cochran,
just these 2,
wait,
Your Honor?
we're not revisiting that at this point. The point is, at some point in time, it becomes cumulative. So you will have, in the record, after Bell, Terry, and McKinney, you will have 3 witnesses that that you can reasonably argue from that Detective Furman is A, a liar, and B, a racist.
Your Honor,
That is a collateral issue.
with all due respect, Your Honor.
Well,
with
wait a
regard-
minute, wait. I'm just saying that then if you want to bring in Hodge and Singer on a collateral issue, at some point in time, it's going to be cumulative.
Your Honor,
If you make a tactical judgment who you want to bring on first and who you want to bring on second, that's entirely up to you. But the cards are on the table. We all know who the witnesses are, but at some point in time, enough is enough.
Judge, you just finished telling us that how the jurors came back barking at seals. You want to get something done today. We've indicated to you, these witnesses, Your Honor, all live out of state now. We're bringing these people back all at his expense. Nobody's paying for this except Mr. Simpson. So we have 2 witnesses here we've had since Wednesday in an effort to finish this case. So we say to you as an offer of proof this morning, we have these people available. We're trying to accommodate the court. We were sitting for 2 days for this order. Now you say to us, well, you make a tactical decision. Terry and Bell, you previously said we could call. The other 2 we think are also very important. Reasonable minds may differ about what is collateral, and perhaps when you hear the arguments...
I'm just telling Mr. Cochran, understand what I'm saying.
Yes.
It might make the subsequent witnesses redundant. That's all I'm saying. I don't know.
Well, Your Honor, let me say this, Your Honor. You're the only one who will ultimately know that. it will never be redundant to us because we think, or we have this overwhelming evidence against this man having perjured himself and being a racist, and this man being a key witness in this case, we think it's important to show this. I just remind the court that we have been 6 weeks, they have been 6 months. And it's not fair to Mr. Simpson that all of a sudden we have to rush through everything now when we get to the end of the case. Now, we understand that, but we weren't, the other 6 months, what they were putting their case on. And so I'd ask the court to remember that when you make these kind of judgments. We want to get this case to the jury also. But at the same time, we also have to fight for our client to get a fair trial on a level playing field, Judge. That's what we're trying to do. So, I mean, so you put us in this quandary. We come to you and say, we got these two people here. They're here from, they're both from back east. Way back east.
Counsel, the scenario that you set for me was that Ms. McKinney was going to testify next.
Yes, absolutely, Your Honor. But then we got your order last night at 4:30 or so. We don't understand that order, clearly. We're going to obviously be asking you to reconsider that order. We're going to point out to you, you may think it's clear, where it's not clear. We plan to do that for early Tuesday morning.
Well,
We're going to ask you.
I just explained it to you.
Well, I think that among us, we still have some difficulty with it, and we still would ask you to reconsider certain aspects. Now, with regard to McKinney, if we are told, let me just say this one thing, if you allow me. One of the things we've talked about a lot in this case is misleading the jury. Mm-hmm. How in the world can we be part of your order and play those two instances that I grew up in Washington where there were no blank words? The other thing, that's where they live and talk about the black Muslims. That's not representative of what happens. This man has been painted as a choir boy, Your Honor, to this jury. And and the jury ultimately makes the decision. We're now left with, sure, we can talk about 41 references, but you pick instances where it doesn't allow us to show what he's done as it relates to this case. And that's what we have a real problem with. We don't think that's fair. If you understand what I'm saying. The two instances, and I don't know how you picked them, those are not the instances that we think are appropriate. Not even mentioning the other 18 things of misconduct on a theory that is the probative value is outweighed by the prejudicial effect. And I'm not going to argue it now except to say that when you make that kind of a blanket order in this kind of a case, where perhaps never before in the history of criminal jurisprudence has there been this level of impeachment out of somebody's mouth, that causes problems for the defense. I think you might understand that. And you might understand that we stand before you today not having a lot of sleep.
Mr. Cochran, here's the problem, though. This is not a motion to reconsider at this point.
No,
you should understand.
Just alerting you that's happening on Monday, Tuesday.
Well, I expect that.
Okay.
You also can walk down the street a block and a half and go to the Court of Appeal if you don't like the ruling.
I understand that. We understand all our remedies. But we got the order last night at 4:30 or so, Judge, is what I'm trying to say to you.
All right.
And I have witnesses here, and we are prepared to put them on. And then you say, well, wait a minute, if you put them on, you might run into cumulative. So obviously we're concerned about that, Judge.
They're saying they're going to make the argument. I'm just warning you that that's a possibility. That's all I'm doing. You want to call him? Call him.
No.
Were these people on your witness list?
Absolutely. They've been told, we gave them to them last Saturday.
So we were told that the next witnesses were going to be Blasini, Goburn, and Manzioni, and with McKinney ahead of those. That's what we were told. It's Friday. It's a short day. So obviously we would not be wasting our time preparing for Hodge and Singer. And of course, the prosecution had no idea as to what the court would rule on the McKinney issue. And so we had to prepare on all 41 incidents. But my point here is, again, why are we being jammed this way? Just because
You're being
they're
jammed
holding us
because
hostage, Judge.
I got a jury that's going nuts. That's why you're being jammed.
They're holding you hostage, us hostage, and the jury hostage as well,
No.
Judge.
But you've known about this witness for a long time, Mr. Durden.
And the next representation I want to make to the court about this witness is that the discovery we have is not consistent with Mr. Bailey's representations. If there are other reports, other statements to investigators, other notes as they relate to Hodge and Singer, we would like to have them now.
And same with our discovery. Mr. Douglas, who handles all of our discovery, gave the district attorneys all of our remaining witnesses last Saturday. They've known about all these witnesses. No question about that. Absolutely. Called, gave them notice last Saturday. She's right here. And so they've known about it. This is just we need obviously a moment to caucus with regard to what your Honor has indicated, because it's not just us, it's Mr. Simpson. So I'd like to talk to my client about it.
A minute to caucus. 352 has been in the evidence code for 50 years. I mean, it's obvious that at some point issues become cumulative.
My remarks are directed to Your Honor.
Yeah, they should be.
All right, guys, we're getting
Put something on the record, Joe.
Briefly.
Yes, you had asked whether or not they had had an opportunity to talk with Ms. Singer. Ms. Singer received a call from Mr. Pelicano, who indicated he was working with the prosecution last March,
This is untrue.
Wait,
Why do we
wait,
allow him to
Mr. Darden, don't interrupt Mr.
as a
Bailey.
result of which she hired an attorney in Nashville. He affiliated an attorney here. She has been prepared to talk with the government in the presence of her attorney since then. Today is the first time they have ever asked, number one. Number two, on suggesting that we run the risk by calling these two witnesses on this one point of collateral estoppel later on. Excuse me, Mr. Darden.
Wait, Mr.
Attorney
Darden.
Rule, Judge.
Mr. Darden, I'm going to instruct you not to interrupt Mr. Bailey again on pain of being held in contempt. Do you understand that?
Judge,
Mr. Bailey.
If it please the court, I respectfully request that you remember the circumstances of Bell and Terry. They are completely separate. They were brought in by the prosecution at the opening of Furman's testimony, and the issue as to them is not racism. It's whether Furman lied when he said he didn't even know them. Because if the jury concludes that that was a lie, they certainly will accept that he made the remarks they attribute to him. That is a box they built and should not be used to accumulatively exclude witnesses who directly impeach Furman, who lied in a capital case, which under Alaska v. Davis is not collateral. Thank you.
so
Mr. Darden.
I'm just wondering if anybody else wants to argue the 352 issue for the defense. I mean, you issued a ruling on this yesterday. As far as Hodge and Singer is concerned, what do you want us to do? You want to jam us, Judge? Put them on. Let's get on with the trial then.
Are you ready to proceed with them?
Am I ready? No, I'm not ready. Frankly, I don't feel I'm competent to represent the people of the state of California this morning as it relates to Mr. Hodge. But
How long is this testimony going to take?
Each witness is probably good for 10 minutes, 15 direct.
that's what he said about Furman.
All right, I don't see there's any chance we're going to, because we're going to have to bring the jury down, I don't see any chance we're going to finish more than the direct this morning.
Can we hear what Mr. Hodge's testimony is expected to be?
I'm sorry?
Can we have the 402? Can we hear what it is he's going to testify to?
I thought we had an offer of proof.
Yeah.
All right,
We
I
have no records
anticipate.
to support that, Judge. Oh,
Page 39039.
With regard
All right, wait a minute, I need to resolve this issue. All right, we will proceed with Mr. Hodge's direct testimony. We will not complete that this morning.
May I do one other thing? Obviously, there's two things that I'd like to discuss. If there is a possibility that by calling Hodge, you would not let us call Kathleen Bell, who they're all flying here this weekend, I've got to discuss that with Mr. Simpson, Your Honor. I can't just do this just to accommodate that. Do you understand what I'm saying on that? Also, there's something else about Hodge's testimony I should indicate as an offer of proof. I talked to him in the break. I'd like to make.
What is that?
That, and I'm not sure the original offer of proof contained all this. Mr. Hodge will testify that he had numerous contacts with Detective Furman between 1985 and 1987. That in addition to these numerous contacts, he made numerous complaints with Internal Affairs, complaining about how he's being harassed by this officer. And that the other things Mr. Bailey indicated, he referred to him as, with the N-word, he had him bend over and take his pants down, all those things that he will testify about. But he had numerous contacts with this officer. He also had contacts with Detective Purdy. Purdy was at the time when he was arrested, it was Purdy and Anderson who first stopped him and arrested him before Furman and Vitriano came and got him. So you should know that also. But the point I have to make is with our client as to so he can understand what the risks are. I need time to do that, but I can't.
All right, bring the jury down.
Would you inquire of the defense? Is there more discovery? I mean, are
They've
there
indicated,
more offers of proof?
Mr. Douglas has indicated you have what they have. All right, bring the jury down.
Yes, sir.
All right, do you have Mr. Hodge available?
No, we're ready to sing it.
Thought we talked about Mr. Hodge.
I'm saying, Mr. Hodge, rather not start him today and finishing Monday, Miss Singer, so we might be able to finish today instead of a couple of extra minutes. I sent word back to the court, but we wanted to call Miss Singer.
No, our discussion revolved around Mr. Hodge. Call Mr. Hodge.
You wanted me to call Mr. Hodge?
No, I'm saying that's the witness that we just finished discussing, that I've indicated I'm going to direct that the prosecution go forward with this witness since they've had adequate time. We did not discuss Ms. Singer.
Sorry, I discussed both this morning. They've had the same amount of time for both. They never lifted a finger to try and talk to her. That's a lawyer's obligation. You can't come in here and say, oh, Judge, I didn't think they'd call her. She's been on the witness list. Well, why does the court say call Hodge?
No, Mr. Bailey, we just finished discussing Mr. Hodge. I just finished looking at the discovery notes regarding Mr. Hodge. I didn't contemplate anything with regards to Ms. Singer. If you want to call Ms. Singer, you'll do it Tuesday, after I've had the opportunity to look at this and hear what their objection is. We just finished.
Call her Tuesday.
All right, may I ask one last question, Your Honor? Mr. Hodge is my witness. I'm ready to proceed. The question I want, and Mr. Simpson, directly from Mr. Simpson, if I call Mr. Hodge right now, is the court going to entertain a motion and grant a motion for 352 on Kathleen Bell and Andrea Terry and Natalie Singer? That's a question he asked me, and I think I have a right to bring that out to the court.
I don't know. It depends on the nature of the testimony, counsel. At some point in time, this is going to become cumulative.
We're fully aware of that, Your Honor. We are aware of that. So he has, but as Mr. Simpson wants, he would like to know that before he proceeds and calls Hodge now, because obviously we've always thought, based upon the people introducing the letter, that Kathleen Bell and Andrea Terry would be called in Furman's testimony.
Well, counsel, you have to make a tactical decision based upon your legal knowledge and experience. You have to rely upon Mr. Bailey's argument, perhaps, that there are reasons independent to call Bell and perhaps Terry. If you recollect, there was also testimony that he had no idea who these people were and denied having ever talked to them.
Call that?
I don't know. But I don't know. I can't make these judgments until I hear what the testimony is. It's very difficult for me to divine these things.
No, I understand that. And this has come up because Your Honor did mention this to us. So
I mentioned it because they made the objection.
I understand, Your Honor. Just a second. May I propose something to the court? I'd like to, after talking with Mr. Simpson and my co-counsel, we propose that we start Tuesday with Bell and then Singer, and then we'll come back to Hodge and with Bell and Terry and then Singer. That way we don't lose anything. Mr. Simpson is adamant that the jury's been told about Bell and about Terry, and he does not want to lose that chance. Your Honor can't prejudge it. You won't tell us at this point. So he doesn't want to lose that thing, and I can't tell him what your ruling is going to be. I understand it's a tactical decision, and I think tactically that's what I've got to advise him, that he wants to start with Bell first then. And they cannot be here. She lives in another state. She'll be here Tuesday morning.
Mr. Darden, any comment on that?
Your Honor, the delays that we have endured the past couple of days, these are delays brought about by the defense. Their failure to get to you.
Part of the delay is I've got to sit and think about these things.
Well, the other part of the delay is they didn't get the stuff to you last week when they were supposed to.
Well, let's not nitpick over that.
Well, my point is simply this. We're going to have a 6-day delay now. We're going to have the jury wait at this hotel for 6 days.
Oh, they'll be doing things.
Okay, Mr. Hodge is here. Okay, he is here ready to testify.
Well, their case, they get to make the decision.
Well, the court ought to order them to either call him now or preclude him, Judge.
No, that's not the way it works. I wish it worked that way, but it doesn't.
Well, surely the way it doesn't work is that they just get to delay these proceedings for days and days on end until they're ready to call a witness.
No, I understand their tactical reason for wanting to call Bell first. Because Kathleen Bell was discussed in the opening statement, that witness has been promised by the defense, and there's a particularly unique fact situation with her that they don't want to lose.
Okay, there are also
They don't want to risk that.
there are also 15 lawyers on the defense, and I'm sure somebody
Well,
thought of this before, Judge.
They probably did.
What about Blasini, Goldberg, Manzioni, and the other 20 or so witness names they float through the air from time to time? What about those people?
Well, the commitment from the defense is we're going to start with Bell and Terry. Where do we go after Bell and Terry?
Well, it would be Bell, Terry, probably we'll start with McKinney. By that time, we'll
Bell, Terry, and McKinney. All right.
We'll deal with tapes, and we'll deal with Singer, and we'll deal with
Hodge.
Hodge, and we have Vetriano, and we have there that psychologist that would be Mr. Goldstein.
All right. On the psychologist?
Well, Dr. Goldson's never spoken to Detective Berman or
Well,
anybody else.
We'll take up that matter.
Those are witnesses we're talking about.
I
All
just
right.
want to alert the defense that there's
right.
going to be an end to these games at some point. The court's going to hear what's going on.
I'm here for one side, one lawyer on the side here.
That's a different issue, Doctor.
It is.
What's his name? I'm sorry.
Thanks.
Goldson. My apologies to the doctor.
So we're clear on, I just want to make sure that we get a final list from the defense so we know. it's
That's what I just
Bell,
asked. That's what you just got.
Bell, Terry, McKinney, Singer, Hodge, and
Dr. Golds.
Goldston. And that's it?
I would imagine
There's Mr. Lazini.
Menzioni.
Furman, we're going to be calling Furman. Lazini. Well,
What about Goldberg and Menzioni? Rivas, Mansuda.
Yeah, they put the defendant on the witness list. We can handle him today. We're ready for that.
He's here.
We're ready for that.
Nice try.
Okay,
All right.
can I inquire, Your Honor, ask the court to inquire about Blasini, Goldberg, Menzioni, Rivas, Mansuda?
Mm.
And we have all these names floating around.
Well, you've been given a half dozen names that are interesting witnesses, so
Yeah, the problem
Be
is
ready.
because of all the discovery violations, one car made
wait,
it on, okay.
wait. Deputy McNair? I'm sorry, Deputy Jex? Jurors, please.
These are brief witnesses. We're not gonna take.
They're not here. We got,
No, I realize. What I'm
We've-
saying is that we need more than this. This won't take up a morning. And we are entitled to 3 days, aren't we, of witnesses? This is not it.
you think Bell is going to be a short witness?
There.
Okay.
There's no mistake about it, what we comes
Wait, Your
out.
Honor, I was addressing the court. I asked that the court require the defense as to what the remainder of the witnesses will be, because the witnesses they have listed will not consume the morning.
We decided on the weekend, I told her, and she should add Mr. Simpson to me for that. If they want him so
All
bad.
rise.
Be seated. Let the record reflect that all the members of our jury panel have rejoined us. Folks that we haven't seen for several days. I seem to recognize most of you. Morning, ladies and gentlemen. Understand that the ride back yesterday was a little rough. Pretty rough. I understand Deputy Dinwiddie was the worst of them all, and thank you for the Catalina hourglass. I appreciate that. As you know, we've been engaged, as I mentioned to you the other evening when I came over to the hotel to talk to you all, that we've had some serious evidentiary problems that I've had to resolve and that we've been working on ever since. And part of the problem was one of the issues was very complex, and I had to take 2 full days both here in the courthouse and at home, working on some of these issues, and we pretty much shot the day resolving those matters. So I apologize to you. The bailiffs have communicated to me on 6 separate occasions this morning that you are not happy campers to be kept on ice again for such a long period. And the attorneys will tell you, will nod in unison, that my proddings to them are always, we have to remember that we have a jury that is sequestered and that is sitting and doing nothing and essentially going nuts while we're out here arguing these legal points. And I want you to know that we are all very cognizant of the fact that you're back there, or that you're back at the hotel. We know that you don't all like to go shopping all day, every day. And I apologize to you. I've tried to convey to you how personally I feel for your welfare. And I know that you're not happy to hear this again. But we have concluded the session. I have other sessions scheduled this afternoon with the lawyers to try to resolve these matters. I had wanted to at least get one witness on and started in front of you today so you would feel that the day was not a complete waste of your time. But unfortunately, the time has come where we just don't have enough time to do that for the remainder of the day. I don't want to be overly dramatic about this with you, but I want you to know that it pains me deeply to know that you're there and that we're not accomplishing things, and it seems to you that we're not moving forward. And I can't think of any other way to express it other than to tell you that I'm deeply sorry for that. I'll do my best to make sure that you have some other activities to take up your time, and we will proceed with witnesses Tuesday morning when we come back after the holiday. So having said that, oh, by the way, thanks for the cigar. Appreciate that as well. Remember my admonitions to you. Don't discuss the case amongst yourselves. Don't form any opinions. This is especially important. Do not allow anybody to communicate with you with regard to the case. You may have a deep curiosity as to what it is that has interrupted the trial for such a long period of time. And at some point in time after the trial is over, we'll let you know what that is. But you have to remain steadfast in your commitment to the court that you will not allow anybody to communicate with you with regards to these matters. I indicated to you when we started the trial that we will keep a compilation of the press clippings, some of the television coverage on videotapes, so that you'll be able to find out what the big deal was, or wasn't, as the case may be, while you were being kept in the dark. And I understand it's not fair to you. It may not seem fair to you, but at some point in time you will be able to know what it was that was occupying our time here. I can just assure you that this has been very difficult for me. It's been very difficult for the lawyers, and it's been a very difficult process for us all. And I know I share the opinion of both sides that we are deeply saddened that this has been a burden to you. All right, having said that, we'll stand in recess as far as the jury is concerned until Tuesday morning. As far as the lawyer is concerned, we'll stand in recess until 2 o'clock.
Case clear.